Good afternoon, everyone. My name is Laura Huizar, and I'm a staff attorney with the National Employment Law Project. Welcome to today's webinar, which NELP is co-hosting with our great allies at the National Immigration Law Center, or NILC. Thank you for joining us. As you all know, the changes that have come with the new Trump administration have changed the landscape for immigrant workers around the country. Now more than ever, immigrant workers are at risk of deportation and retaliation from employers. So this webinar aims to address some of the key protections that workers have relied upon to assert their rights in the workplace, and it will assess the status of those protections. We have some great experts to guide us through the discussion today. First, Tricia Smith, the former Solicitor of Labor with the U.S. Department of Labor and now Senior Counsel at NELP, will talk about the Memorandum of Understanding between the Department of Homeland Security and the U.S. Department of Labor, the Equal Employment Opportunity Commission, and the National Labor Relations Board. The MOU was designed to protect workers engaged in a labor dispute from worksite immigration audits. After Tricia, Matt Ginsberg, who is Associate General Counsel at the AFL-CIO, will guide us through the ICE memorandum regarding I-9 audits during labor disputes and what that means for workers today. Then Eunice Cho, a staff attorney with the Southern Poverty Law Center in Atlanta, will talk with us about U-visas, which have been available for immigrant victims of crime in the workplace, and she'll take us through some recent changes that could affect that protection. And finally, Jesse Hahn, the Labor and Employment Policy Attorney at NILC, will discuss prosecutorial discretion for immigrant workers involved in the labor dispute, as well as the confidentiality of labor records, something that's been complicated by this administration's elimination of Privacy Act protections for undocumented and foreign-born workers. Our panelists are each going to speak for about 10 minutes, and then we will open it up for questions. If at any time during the webinar you have a question for our panelists, please type that question into the box on the left hand of your screen, and we will moderate a conversation using those questions after the panelists have spoken. So you will be muted during this webinar. Only the panelists will be able to speak on the line, but please submit your questions at any time. We will also be sending an email out after the webinar with a link to the audio recording of the presentations. So at this point, it's my pleasure to hand it over to Tricia Smith. Thank you, Tricia.
Thank you, Laura. So what I want to do today is to talk about the Memorandum of Understanding between the labor agencies, the Department of Labor, the EEOC, and the NLRB. It is my understanding that that Memorandum of Understanding continues to exist and be in effect. It does have its limitations, so I want to talk about that. First, for those who don't really understand how it operationally works, what I would like to do is describe that. The Memorandum of Understanding is a deconfliction memorandum, meaning that if there is a labor investigation open at one of the agencies and ICE is going to do an I-9 audit, and that's an important thing. It's about I-9 audits. They will send over to the Labor Department their list of proposed places that they were going to do audits, and then the Labor Department will coordinate with the other agencies and deconflict, meaning if there's a match, if they say we're going to Papa John's on 6th Street in New York City, and there is either a Department of Labor, and that could either be a wage and hour or an OSHA investigation, or theoretically an ERISA investigation, or an EEOC or an NLRB open case, that will be a match. If there is a match under the Memorandum of Understanding, unless ICE was investigating a criminal case, they will stand down, i.e. they will not do that investigation during the pendency of the labor investigation. And it's the obligation of the agency in the future, when they finish that labor investigation, to tell ICE. That's the main part of that MOU. There's also another part of the MOU where ICE acknowledges that they don't want to interfere with labor investigations. And so if the agencies have some reason to believe that the employer is going to retaliate, call ICE, they can proactively reach out to the contact with ICE, usually through the Labor Department, to say, we have this labor investigation. We have reason to believe that the employer is going to retaliate in some way, maybe by calling ICE. So if you get a tip, or you get a call, this is a place that you should not go. And again, my understanding is that that MOU in that way continues to be in effect. What you have to understand is the context in which this MOU was negotiated. It was negotiated relatively early on in the Obama administration. It was like a year and a half ago or 2 years ago that the EEOC and LRB were included in that memorandum of understanding. At that time, the Obama administration's main workplace enforcement were not raids, but they were I-9 audits. They were moving away from workplace raids, and they were doing workplace enforcement through I-9 audits. So although we haven't heard to date a lot of information about workplace raids, it's a little unclear how that MOU would work in that context. My understanding is that the I-9 auditing function of ICE and the individuals who go out and sort of pick up people or do raids aren't necessarily the same people. So it's not clear to date that if indeed we see an uptake in workplace raids, that ICE will be giving that information in advance to the labor agencies so they can deconflict. So that really is what's happening with the Memorandum of Understanding. I think one other thing that we need to remember, because I know people are concerned about the President's Executive Order and the Privacy Act, which will be discussed later on, but at least at the Department of Labor, if you file a workplace complaint, the Department of Labor records, they don't ask what person's immigration status are. The Department of Labor records would not reflect immigration status in any of either their wage and hour cases or their OSHA cases or their other enforcement cases. So even if the Department of Labor had to turn over all the information they had about open investigations to ICE, ICE would not be able to figure out what someone's immigration status was. That obviously is a little bit different with U visa certifications, because one doesn't really apply for a U visa or a T visa unless they have issues with their documented status. But we can go into that a little more later when we talk about that. But when it comes to filing workplace complaints, there is no information in the Department of Labor's files that would indicate someone's immigration status. I have heard that obviously people are very, very nervous. That's an understatement. But they're afraid to file complaints. They're afraid to, I've even heard stories that individuals are afraid to come in and claim money that the Department of Labor has collected on their behalf because they don't want their name on some sort of list. But again, there's no way that you could be able to use Department of Labor records outside the U visa context to make any assumptions about someone's immigration status.
Thank you, Tricia. That's very helpful to hear. And I know we're having some issues with the audio at this point. We're trying to resolve that. If you have called in and are hearing a signal or music, we will try to make sure that a chairperson gets to you in a moment and opens up the line. If you can try calling in through your computer, you may have better luck at this point. but we do apologize. We're trying to resolve that. And we will send out a full recording of the presentation with materials by email after this presentation. So thank you, Tricia. Matt will keep going along for now. So Matt Ginsberg, everyone, thank you, Matt, for joining us.
Sure. And I think if we could move to the next slide, if that's possible. Give that a second. Well, I'm going to get started, and there we go. That's me. And then once people have seen that, if you could move to the next slide, which back one, please. Thank you. Perfect. Hi. No, forward one, please. Sorry. There. No, back one, please. Do one last try. There we go. Thank you. This is Matt Ginsberg from the AFL-CIO, and I wanted to thank NELP and NILC and my co-panelists for putting together this very useful presentation and very timely presentation. So my topic that I'm going to speak about follows sort of logically from Tricia Smith's presentation on the Memorandum of Understanding. I'm going to speak for a few minutes about the ICE guidance on non-interference in labor disputes. The current guidance, which you see listed under the first bullet point here, is the 2016 guidance on civil inspections of the Employment Eligibility Verification Form, Form I-9, during labor disputes. And that policy, which was issued last year, superseded a long-standing policy about 2 decades old called Operating Instruction 287.3a. That was the original name of the policy. It went through a couple different titles, but that was essentially the policy that was in place for approximately 2 decades. I'm going to focus on the top policy, the 2016 guidance. And what this policy is general guidance to ICE, interagency guidance to ICE regarding non-interference in labor disputes. And I want to make a couple points about what the policy is and what it isn't, so folks have a sense of what the breadth of the policy is. So the policy says in broad terms, again, speaking to the agency itself, that ICE respects the labor rights of workers regardless of immigration status. And that's a quotation. That's the first sentence of the policy. And also it says more mechanically that when information is received by ICE concerning the unauthorized employment of aliens, consideration should be given to whether the information is being provided for the purpose of interfering with a genuine labor organizing campaign or employment dispute between workers and the management or ownership of the business or organization, and then list a variety of types of employment disputes, which is quite broad. And so the real thrust of this policy, this internal agency policy, is to tell ICE and its agents that it is not ICE's purpose to interfere with ongoing labor disputes, and to, in broad terms, define what those covered labor disputes are. This is not a interagency policy of the sort that Tricia just described with the MOU. Rather, it's internal guidance to ICE agents. In addition to that the general policy, which I've just read to you, the 2016 policy, the guidance listed here, also reiterates that ICE agents have a duty to deconflict their investigations with the Department of Labor, the National Labor Relations Board, and the EEOC, pursuant to the Memorandum of Understanding and the addendum that Tricia just spoke about. So there's a cross-reference in this internal agency guidance to the interagency MOU. And in addition to that, this policy refers to a process by which if there is an I-9 inspection, and as a result of that I-9 inspection there are individual employees who are detained who one of the labor agencies need as witnesses, this policy sets forth in fairly general terms what should happen, which is basically that ICE should cooperate with the labor agencies to allow them to make available for interview those detained individuals. And finally, this policy references generally or provides a reminder to ICE agents that they are reminded, and I'm quoting here, to refer to all relevant existing policies, including policies related to treatment of victims and witnesses, as well as DHS's civil and immigration enforcement priorities in undertaking I-9 audits. And so to the extent there are other policies, which this is fairly broad language, I would suggest would include U-visa policies, T-visa policies, other policies where ICE is to look at the characteristics of folks they might pick up during labor disputes, that this is an internal agency reminder that those policies should be considered. So again, this is internal agency guidance, but it does set forth the basic policies of non-interference in labor disputes and what to do when an ICE I-9 audit takes place and ICE later learns that, in fact, there is an ongoing labor dispute at the workplace. What this policy is not is it's not a prohibition on undertaking audits in those situations where there is no labor dispute covered by the MOU in progress. The policy which is available, which is, I'll talk a little bit about how it became available, but it is somewhat redacted, suggests that there is no absolute prohibition on ICE undertaking an I-9 audit in cases that are not covered by the MOU that Tricia described earlier. Also, this policy is not a prohibition on criminally based audits or worksite enforcement. So to the extent that ICE is undertaking a criminal investigation, this policy on its own terms does not apply, although I think it's still worth reading for sort of a general understanding of what ICE's stated views are on avoiding interference in ongoing labor disputes. Having said all that, in terms of the content of the policy, there is, as with many of the topics we're discussing today, an open question of exactly what the status of this policy is in the wake of the Department of Homeland Security's February 20th, 2017 memo, Enforcement of the Immigration Laws to Serve the National Interest, which states that it rescinds certain prior enforcement and priority policies that are in conflict with that memo. Now, it's unclear both whether this particular guidance would be considered an enforcement and priority policy or whether it would be considered to be in conflict with that memo. And I don't have any information one way or the other about what DHS's or ICE's view is on that question. But as I'll explain in a few minutes, I think regardless of the precise answer to that question, since this is internal agency guidance, I think it is still a valuable tool for advocates to know about. And I'll just take 1 or 2 minutes here to say a little bit about the background of this document, as well as refer to Operating Instruction 287.3a, the second document listed here. And maybe while I'm speaking, if we could just move to the second slide, which just summarizes some of the key points that I just spoke about. Great, perfect. And those are the key provisions that I have already referred to. Anyway, so just as background, the original policy, the operating instruction, was set forth in 1996, again as internal agency guidance and with many similar terms to the current 2016 guidance. So that policy of non-interference in labor disputes has been in place for about 2 decades. It is true that when it was originally promulgated in 1996, that was during the Clinton administration, and there was quite a bit of openness to hearing from advocates about when labor disputes were going on, and labor advocates were willing to affirmatively contact ICE to tell ICE there's a labor dispute, at that point INS, to tell INS that there was a labor dispute going on at a particular workplace, and therefore under INS's policy, Operating Instruction 287.3a, INS should avoid any enforcement activities at that workplace. During the Bush administration, the policy remained in place, but it was moved out of the operating instructions that INS and then ICE had, and sort of downgraded. And around the country, there certainly were reports that we received that certain field offices were not recognizing that it continued to be agency policy, although as a formal matter, it still remained on the books as agency policy. There certainly, in that situation, there were places around the country where advocates were quite hesitant to affirmatively contact ICE about ongoing labor disputes in fear that it, in fact, could trigger additional scrutiny or an additional enforcement action by ICE. While in other places where advocates continued to maintain open lines of communication with their local ICE offices. Even through the Bush years, there were places where advocates continued to use the operating instruction as a basis to contact ICE. In the Obama administration, we had a big push to revise the operating instruction, which at the time still referred to INS. And late last year, they did revise it, leading to the guidance which I've been speaking about today. Unfortunately, we at the AFL-CIO had to FOIA that document to get it publicly released, and so the version we have today is somewhat redacted. But it was put into place last May, and as far as we know, continues to be agency policy. So to close out, I just wanted to wrap up with a couple of practice pointers. Whether or not the 2016 guidance remains formally in effect, the underlying policies, which are very similar to those that were put in place in the operating instruction in 1996, are longstanding within the agency, and more importantly, are really common sense. ICE is a law enforcement agency, and a law enforcement agency like ICE isn't in the business of allowing itself to be manipulated by employers who are seeking to retaliate against their employees for bringing forth labor claims. And especially ICE shouldn't be willing to be manipulated by employers who are themselves violating the law that ICE enforces. So the policy, operating instruction, and the current 2016 guidance is really common sense. So whatever the formal basis for the policy, it certainly sets forth some common sense principles which provide a basis for advocates to talk to ICE about these sorts of situations. And with that in mind, my second practice pointer is that it is well worth an effort to create a relationship with your local ICE office and the Homeland Security Investigations folks there in advance before you have one of these problems. Amongst other things, this can give you an opportunity to gauge whether, if you do have a problem where you fear employer retaliation on the basis of immigration status, whether it makes sense to affirmatively alert ICE of that ongoing labor dispute. Is this the sort of office that you have a good chance, who seems to understand the policy and respect it, where you'll get cooperation, or is this the sort of office where you might be hesitant to do so? It's to state the obvious, it's helpful to gather that information by developing a relationship in advance rather than waiting till the midnight phone call when there's a problem and you have to, for the first time, reach out to your local ICE office. So again, the policy is a common sense one, and whatever its formal status, it's certainly one that is worth knowing about and speaking to ICE about. And I suggest developing a relationship with your local ICE office in advance of any issues so that you can have an open line of communication and feel out exactly what their knowledge and commitment is with regards to this policy. And I'm happy when we're wrapped up to take any additional questions on the details.
Thank you so much, Matt. That's very helpful. And we'll come back with questions for Matt at the end. I'd like to pass it on to Eunice to talk to us a little bit more about U visa protections. Thank you, Eunice.
Thank you, Laura. If we could forward to the next slide. And the next slide after that. So my name is Eunice Cho, and I'm a staff attorney with the Southern Poverty Law Center and a former staff attorney with the National Employment Law Project. Today I'll be talking about U visa policies with respect to victims of workplace crime and how, if any, these policies may have changed under the Trump administration, and some practice points to think about for practitioners who are contemplating filing U visa applications for clients who are victims of workplace crime. So as we all know, U visas are visas that are meant for victims of crime, and in the last few years several labor and employment agencies have actually used this as a tool to help encourage cooperation and support in labor investigations. So labor agencies at the federal level, such as the EEOC, NLRB, and DOL, have all issued certification protocol to certify that immigrant victims of crime in the workplace have been cooperating with investigations or prosecutions of these workplace-related crimes. And of course, there are multiple agencies that are involved. First, you have to show that you have been cooperating with that sort of detection or investigation. And then the certification then goes to USCIS, U.S. Citizenship and Immigration Services, which is a component agency of the Department of Homeland Security, which then adjudicates the petition to see whether or not the person should get a U visa. So it's a two-step process. So there are multiple areas where I think I know individuals have been wondering about changes under the new administration. And just to report as an update, based on our conversations with different federal agencies, the EEOC, the NLRB, and the USDOL all report no changes in terms of the certification policies that exist. So these agencies are all continuing to receive and review visa certification requests as before. So these protocols are all available in a NELP U-Visa Practice Manual. So if you actually just Google NELP U-Visa Practice Manual, it'll pop up. But I know that the NLRB has reported that they are still reviewing U-Visa certification requests, no change in policies, and the NLRB is still led by General Counsel Griffin, whose term is valid until October 31st. The EEOC has the same analysis as well. So in terms of certification, all of those policies are still the same. That is also true of many state and local agencies that certify U-Visas. So there are some updated, I think there are new agencies that are starting to look at U-Visa certification. One such example is the San Francisco Office of Labor Standards Enforcement. So that's another jurisdiction in which if you have a workplace-related crime, that may be another certification possibility for advocates. And as usual, we really encourage those of you in states that are not, that do not have U-Visa certification protocols to continue advocacy efforts and encourage local and state agencies to think about adopting certification protocols. One of the advantages right now to state and local agencies is that they are not subject to the mandates of the federal government, the executive branch in particular. So that may also be an additional selling point in terms of advocacy to get these types of certification protocols passed. Could we move on to the next slide? So there have been a lot of questions about what happens to the information that is submitted to agencies, either the certification agencies themselves or to USCIS when there's a U-Visa application. And I'll be talking a little bit about a federal statute called 8 U.S.C. Section 1367, which actually talks specifically about confidentiality provisions for U-Visa applications. This statute is relevant because it provides some minimal protection for U-Visa applications. These are the actual materials that are submitted to USCIS, as well as any information. So you can see that the statute says that the Department of Justice, DHS, and the State Department specifically may not permit the use of disclosure of any information related to an alien who's a beneficiary of a U-Visa application. So that includes people who are the applicants themselves, the victim of the workplace crime, and derivatives, family members who might also be applying for a U-Visa. And this protection lasts until the application is denied or opportunities for appeal have been exhausted, so as it works its way through the system. There are exceptions. So as you can see, the statute includes exceptions for to sworn department employees or for legitimate department or bureau agency purposes. The DHS or DOJ may disclose this information to law enforcement officials for a legitimate law enforcement purpose in a manner that protects the confidentiality of such information. Judicial review that also protects the confidentiality of this information, and other exceptions like public benefits or congressional oversight, or if a person waives that confidentiality. Now the question, of course, is how far does this statutory protection actually extend? And I think that has become a broad question. We have asked, our understanding is at this point, information that is shared with USCIS, so this is the second stage of the U-Visa process where you are actually submitting an application to USCIS after you've gotten certification from an agency, is that there is no process to allow ICE to access files, and that the USCIS is aware of the chilling effect that sharing files with ICE would have on victims of crime generally. However, I think the analysis has always been, with a caveat, is that USCIS is a sister agency of ICE, and that it would be very difficult not to share information if a request was ever made. That has always been the case, I think, for the last decade in which U visas have been adjudicated by USCIS, and we continue to believe that that is still the policy, and we have not heard any changes to that, to the that don't particularly say that, but that is the present news that we have at this point. The other thing to note is that in some cases, especially if a U visa is a defensive strategy against deportation, that advocates really should not hesitate to file a U visa application in those settings, especially where ICE is already aware of the fact that a person is removable. So in that particular setting, one should always consider filing a U visa application if it is a possibility. Can we go on to the next slide, please? The other update I'd like to share is a case called Cazorla versus Cook Foods of Mississippi in the Fifth Circuit. And I want to actually really recognize the folks at Texas Rio Grande Legal Aid and the EEOC who've been litigating this case for the several years at this point now. I think we also have Stacy Jonas, who's an attorney from TRLA, on the line, who's also been working on this case for years to answer any specific questions about the case if folks have a question at some point. But this case is important in that it looks at, it's the First Circuit Court opinion that looks at whether U visa information is subject to discovery in employment litigation. And the background of the case is that this is a case that arises out of abusive workplace conditions at a poultry plant in Mississippi. There was rampant abuse, groping of female workers, punching, elbowing workers, extortion of demanding payment for workers to be able to go to the bathroom, take sick leave. And so the employees actually alleged discrimination. The immigrant or Hispanic employees, as named in the complaint, alleged discrimination. There was a strong protective order to begin with regarding whether or not immigration information could be obtained in discovery, but through subsequent motions, it became watered down by the time it went up to the Fifth Circuit on an interlocutory appeal. The employer defendant in this case argued that the allegations of abuse alleged by the workers were manufactured for the purpose of getting a U visa from certification from the EEOC. The court then had to consider whether or not U visa information was subject to discovery in employment litigation. And this question went up to the Fifth Circuit. And the holding of the case is that agencies like the EEOC or the Department of Labor who are actually receiving information are actually bound by the confidentiality provisions of 8 U.S.C. 1367. However, the court actually had to look at the second question as to whether or not that provision precluded discovery from individual claimants themselves, so the actual workers. What the court actually looked at was several factors of the balancing test under the Federal Rules of Civil Procedure. So it looked at the fear of being fired reported, the extent of discovery, and actually the analysis as to the effect on non-claimants, the public policy kind of effect, became very key. Is that requiring immigrant victims to provide information with respect to U visas may have a chilling effect more broadly on victims of crime writ large. So the Fifth Circuit did not actually make a specific holding in terms of what the discovery order should look like, and it has been remanded down to the district court to devise an approach that protects all of these interests. I think the question really is whether or not what happens to information that certifying agencies like the EEOC or DOL or the NLRB, not in the litigation context, but in the context of sharing that information with DHS for purposes of enforcement activity. I think advocates' analysis or interpretation of the statute would be that it would apply to all agencies receiving such information, full stop. But I think there's no definitive analysis or judicial holding on this, so that question is still up in the air. I know that Jesse, who's speaking next, is going to talk a little bit further about some of the privacy provisions that more generally that come up in these contexts as well, not just in the U visa but in other information sharing contexts. So I'll leave it to her to talk about that in a little bit more detail. But I hope that this gives a little bit of at least an updated analysis as to what is going on in the world of U visas. Unfortunately, we don't have solid answers at this point, but it does look like, in general, in terms of at least the certification, things have not changed at this point. Thanks.
Great. Thank you so much, Eunice. Let's move on to Jesse Hahn, who is the Labor and Employment Policy Attorney at NILC. Jesse?
Hi everyone, thank you so much, and thank you to everyone who helped put together today's webinar. So if we could move to the next slide, I'll be talking a little bit about cases involving requests for prosecutorial discretion from immigration. So in 2011, DHS put out a prosecutorial discretion memo that some advocates had been using as a basis for making requests for prosecutorial discretion, different types of immigration relief, based on an individual's involvement in a labor dispute. But as panelists have already referenced, on February 20th of 2017, this year, DHS released a new updated Interior Enforcement Priorities Memo, which included language that rescinded prior DHS memos to the extent that they conflicted with the new enforcement guidance. So on the slide you'll see the kind of exact language in the memo. It really is not clear to anyone yet what this means for the victim's memo, because theoretically some cases could fall within the victim's memo and not clearly directly conflict, as the language in the February 20th memo the language used in that memo states. Could we move to the next slide? That being said, we do think that those cases were already very difficult for people to win. We have not heard anything to change what we had known to be the current USCIS policy, as Eunice mentioned, of not sharing information about applicants, whether for U visas, whether for prosecutorial discretion, whether for DACA, with ICE for immigration enforcement purposes, unless there were serious criminal, fraud, or national security issues. So that standard about information sharing between the components of DHS is an old standard that is not unique to U visas or prosecutorial discretion cases. It was an existing standard that was derived from something called the NTA memo. And that being said, though, we do think that we are in a new environment where there are new enforcement priorities. And so especially if someone that you are working with is considering applying for prosecutorial discretion and they have any kind of prior history of contact with law enforcement, whether that's a conviction, whether that's only charges, or whether they have prior removal orders, given the new priorities, we definitely think that those individuals should exercise special caution. And anyone who's considering applying, we think should first consult with an attorney or an accredited representative. Another thing to note is that we've seen one change from the previous administration to the current administration is that if individuals are caught up in enforcement actions, like let's say that they are in the wrong place at the wrong time when ICE comes looking for someone else and they get detained, if they already had a pending application for status, in the past that was most often a reason for ICE not to continue with a removal proceeding against that person. Now we're seeing that being applied more unevenly. So it's not a guarantee that someone would not be removed. It's also not, it does not provide the same level of protection that it used to provide. So that being said, we do still very much encourage people to consider as a defensive mechanism for individuals who are already in removal proceedings seeking prosecutorial discretion based on their involvement in a labor dispute. Could we move to the next slide? So I wanted to include just a brief update about DACA because I know many of the advocates who are joining the call also represent workers who have DACA or are in contact with documented people in their communities. And you know, our current advice is that people should consult with an attorney or a BIA accredited rep before applying for DACA for the first time or renewing, because it's not clear whether the standards, for example, for renewal will be the same under this administration as they have been under the previous administration. And given that applying for DACA is is comparable to applying for other types of prosecutorial discretion, such as being based on a labor dispute or U visas. These are the kinds of concerns that we think could potentially tip the analysis in terms of whether or not to apply. But we really do think that everyone should be having kind of detailed assessments with their own immigration counsel about these kinds of questions. If we could move on to the next slide. So moving on to the privacy question. In the two so there was an executive order that was issued by the President, and then Secretary Kelly of DHS issued a memo on February 20th that was essentially implementing for DHS purposes the language in that Interior Enforcement Executive Order. And what both stated was that the Privacy Act, which by its terms when it was passed, did not apply to anyone who was not a United States citizen or a lawful permanent resident. So the reason that I make that distinction, the reason that I point that out is because executive orders obviously can't change statutes. However, what was happening in practice was that many federal agencies were extending the protections of the Privacy Act to everyone in their databases, which were also known as quote-unquote mixed systems. So in other words, many databases have people who are both U.S. citizens or lawful permanent residents and people who do not have those statuses, right? And many times the databases do not distinguish based on anyone's immigration status. And so many federal agencies had the policy of extending the Privacy Act protections to everyone in a database. According to the new enforcement memo from DHS from February 20th, they are no longer going to extend those Privacy Act protections to people who are not U.S. citizens or lawful permanent residents. Could you move to the next slide? So what does that mean? What are the concerns? Obviously, the greatest concern is the possibility that records in the custody of the federal government agencies could be used for immigration enforcement purposes. We don't know yet the extent to which this is a real danger. But we wanted to make sure that people were aware of the fact that this is one potential area of concern given the changes to the application of the Privacy Act protections to the records of the DHS systems. Obviously, there are also these other concerns about FOIA, about people's ability to correct their records. In other words, with regards to FOIA, previously immigrants' personally identifiable information would have had to have been redacted before being publicly disclosed pursuant to a FOIA request. The language in the new memos may change that. In addition, if people had corrections that they were trying to make to their records, they may now not be able to kind of have the same protections that they would have under the Privacy Act. Could we advance to the next slide? With regards to the confidentiality of the records at the labor agencies, we've checked in recently with folks at both the EEOC and the NLRB. There is strong statutory protection for the information obtained during EEOC investigations, preventing it from being released, and really, and the information is at 42 U.S.C. 2000 E-8E. So the folks at EEOC were very confident that information collected during the course of their investigations would not be releasable to ICE for enforcement purposes. They also said that they had never received any requests like that in the past, and they had never received any court orders like that in the past. With regards to the NLRB, the current general counsel at the NLRB, his term goes until November 2017. Most people are expecting that the policies will change significantly after that time, because we are anticipating that Trump will appoint a general counsel with a very different orientation. So the advice I'm about to give is applicable until November. But what they are telling us is that they would never share information with ICE for immigration enforcement purposes absent a court order, that they have never received any kind of requests for personal information from ICE for enforcement purposes, or court orders to that effect, and also that they allow workers to use the contact information of other individuals, such as their attorney or an advocate or an organizer, when filing charges or giving affidavits if individuals are concerned about ICE enforcement. Another thing that they mentioned to me was that if when a case is filed, there are allegations that the employer is threatening to call immigration on workers because they are trying to defend their labor rights, that ICE in the past, that when those types of cases have been filed, the board has called ICE and told them about that, and ICE has agreed not to take enforcement action at those work sites. So, and that's kind of completely outside of the formal processes that have already been discussed so far in the webinar. So I do think that if you are seeing cases like that, it's worth it to have a conversation with your local board agent about their willingness and ability to make that kind of a phone call. Thank you.
Great. Thanks so much, Jesse, and all of our other panelists. This has been really helpful. And again, we will be sending out a full recording of the webinar and materials once the webinar is over, and we'll email that to everyone. So we've gotten a lot of really good questions throughout the presentations. And I'm going to, well, unfortunately we don't have time to go through all of those questions, but I'm going to ask a few of those until we run out of time at 3:15. So I think that the first question is for Tricia. So Tricia, a couple of people have asked if the MOU that you spoke about would also apply to state agency investigations of labor disputes or complaints. If you could talk a little bit about that, that'd be great.
Yes. The answer sadly is no. This was an issue that was raised both in 2011 with ICE and in 2016 when the addendum that included the EEOC and the NLRB. And ICE has had been reluctant to expand it beyond the federal level. I mean, they're used to coordinating and deconflicting with other federal agencies. Having said that, for those of you that are in OSHA state plan states, the Department of Labor, because of the way that OSHA works, they actually have in their database all complaints that are pending in any state, for example, California, which is a state plan state. And so when it comes to OSHA complaints, they will run that information through their entire OSHA complaint database, and so it will include state plan OSHA states. So if you file a complaint, for instance, with Cal OSHA, that will run through. But other than that, one state plan state in OSHA context, state agencies are not covered.
Great, thank you, Tricia. And I have two questions that I think, Matt, you may be able to answer, and then others can jump in if you have thoughts. So this is, the question is, what are some of the warning signs that an ICE audit or raid of a workplace may be imminent? And related to that, what instructions might a union give to members in case of an audit or raid?
Right. So, I mean, oftentimes our affiliate unions learn about audits that are going on because, you know, somebody, oftentimes it's a member is asked to show that they're authorized to work, to bring in new documents showing that they're authorized to work, or a question is raised about their document, or it could be something as simple as a supervisor telling employees that there were government officials in the Human Resources Office looking at papers. So oftentimes it's a little bit unclear at first whether or not there's an audit that's going on. The key question we always advise unions to find out is this in fact an ICE I-9 audit, or is this the employer conducting a self-audit? And we don't have time to go into a great deal of details here, but there are two different things. If ICE is conducting an I-9 audit, that is the government doing an audit of the workplace. A self-audit is something that an employer is voluntarily doing, and it raises a different series of questions, but it's oftentimes unclear at first which of these two things is happening. In both cases, in shops where employees are represented by a union, the union has both a legal duty and a legal right to bargain with the employer about certain aspects of the audit process. And again, it's that could be its own webinar all in and of itself. But many of our unions have now bargained collective bargaining language about the rights of employees with relation to showing work authorization within the contours of the existing law. And even where a union doesn't have that existing collective bargaining language, they can certainly do things like bargain with the employer about things like the amount of time provided to employees to show that in fact they are work authorized, to bargain for time off, to get new work authorization papers if that's an issue for individual employees, or if employees can't show that they're work authorized, unions can bargain for a length of time for employees to come back to the workplace if later, after the audit, they are later able to obtain work authorization. And so we've had some of our member unions bargain language where employees can come back months or even a year later and come back to the workplace without a loss of seniority or pay. So there's a variety of things that unions can do, but they have to know and respond quickly to the fact that an audit is taking place, and then determine whether this is an ICE audit or a self-audit.
Thank you, Matt. I don't know, Tricia or others, if you have thoughts on that. I can move on to the next question too. Yeah. So let's move on to the next. Oh, sorry. Go ahead. Mm-hmm.
So I think that Matt really had this caution, which is that we really are possibly entering into a new era where the ICE is going to be turning away from I-9 audits to raids, and I think that we have a lot of unclarity about how any of this is going to apply in a raid situation.
Thanks, Tricia. Another question actually maybe for you, Tricia, is can you clarify why it would be in ICE's benefit to give a heads up to a labor agency before they conduct a raid, if that does happen?
Well, it goes back to the basic premise behind the MOU, which is that ICE does not want to be manipulated when there is a labor dispute, and that they believe it is good policy not to interfere as little as possible with the work of other federal agencies. So they might want to know if they're doing a raise, especially if they got a tip, is this because there is a labor dispute going on? So, I mean, those policies could apply equally in raids, assuming they're not criminal. What we don't know yet is whether or not ICE will continue to apply them in the raid situation.
Great. Thank you so much. I think this next question is for Eunice. The question is, to what extent do the lack of changes in U-Visa certification policies reflect the absence of senior officials appointed by the administration? And once those officials are nominated and confirmed, should we expect significant changes in those policies?
That's an excellent question. I mean, I think anyone's guess is as good as mine with respect to what another appointed official would do to change any of these policies. The one thing is that it is under statute at the agency's discretion whether or not to certify U-Visa requests. So it is a purely discretionary decision on behalf of the DOL, the EEOC, or the NLRB. So it is unclear as to what would happen if there was new leadership.
So this is Tricia. I'd like to add to that, which is that I have read very Acosta, who is probably going to be confirmed as Labor Secretary today, both his testimony and questions for the records after. And he was very strong on immigrant rights and the rights of undocumented workers. So we don't really know, but there were very good signs from that testimony that he will continue to be supportive.
Thank you, Tricia and Eunice. The next question concerns the privacy issues that Jesse spoke about. It's actually two questions, Jesse. So one, to confirm, does the Trump January executive order rescinding the Privacy Act protections also affect legal permanent residents? And secondly, a lot of immigrant clients are concerned about the security of W-7 ITIN applications. So can you tell us anything about the IRS's treatment of non-citizen information in light of that executive order?
Sure, yeah. So with regards to the first question, the Privacy Act continues to apply to lawful permanent residents, and it continues to apply to U.S. citizens. But other people who do not have one of those two statuses, the executive order instructed all federal agencies to no longer extend to those individuals the protections of the Privacy Act. With regards to ITIN applications and more broadly documents in the custody of the Internal Revenue Service, the IRS, the IRS has its own very, very strict confidentiality statutory protections that until now we have not had any reason to think that those records could be subject to any kind of sharing or discovery with ICE for enforcement purposes. And I will look and see if I can find the statutory site, and I will paste it into the chat box if I find it before we finish. But we very much are continuing to encourage people to apply for ITINs and to use ITINs.
Thanks, Jesse. And I don't know if do any of the other panelists have thoughts on that question? No. Let's move on to the next question, which I think is a general question maybe for Jesse or others. it concerns the U visa issue. It sounds like folks are trying to understand exactly what they can advise their clients or what they should keep in mind given the changing landscape and the complexity of the issue. Jesse, I don't know if you want to take a stab at that. Maybe Eunice, you can jump in.
Yeah, I think I think more broadly, what I would encourage people to do is not to be dissuaded from filing labor claims out of a generalized fear that deportation could result from filing some kind of a labor claim. Obviously, people will have to make case-by-case assessments, especially in situations where you have an employer who's threatening to call immigration and you don't have any faith that your local immigration office would not kind of take an abusive employer up on that kind of a tip. But that being said, I do think there's a big difference between kind of your run-of-the-mill complaint for a wage and hour violation or a discrimination complaint or an organizing-related issue under the NLRA. I think those things are different than filing for immigration relief. And with regards to the labor certifications, I mean, there's two different risks, right? There's the risk of the certification being turned over to ICE, and then there's the risk of USCIS sharing the information. I think as we've talked about before, applying to USCIS, there are different priorities for enforcement now. And at least with these labor-based cases, some of them were already very difficult, and so people may make the determination that it's not worth it to pursue them if they're kind of thinking that they are already going to be very difficult to prove even under the previous administration with some of the challenges around things like proving substantial abuse. And then also what we're seeing now as far as ICE being unwilling to stay kind of categorically deportation proceedings for people with pending applications. But that being said, we don't think that ICE is sharing is getting information from USCIS right now. They said just last week in a public forum that they were not trolling the records, for example, of DACA recipients for ICE enforcement purposes. So, it's difficult to predict. No one knows what ICE is going to do. But I think we kind of would just encourage people to consult with an attorney and to take into account all of these new changes and make kind of an individualized assessment. And I don't know if other panelists want to jump in and kind of give their 2 cents on that.
This is Eunice. I would tend to agree with what Jesse just had to offer. I think there are some probably different considerations to take if the individual, for example, has a very complicated criminal history, for example. But in general, at this point, I don't know that we have any information that would suggest any major change in terms of information sharing that would result in a recommendation that people stop considering applying for U visa applications in general.
Great. Thank you, Jesse and Eunice. I don't know if other panelists want to jump in on that too. We can move on to the next question as well. Okay. I think the next question actually for Eunice, some folks have asked for just a little bit more context or background about what types of labor violations are qualified for U visa certification. If you could talk a little bit about U visas and wage theft and ways in which advocates may be able to use the U visa process.
Oh, absolutely. Yeah, so in terms of just very generally in terms of U visa eligibility for victims of workplace crime, the U visa statute has specified about 36 different qualifying criminal activities that an individual must be a victim of in order to actually qualify for a U visa. And so they range from different crimes such as domestic violence, which is one of the most commonly certified U visa crimes, to things like extortion, witness tampering, obstruction of justice, extortion. And then there's a few labor-based cases such as fraud and foreign labor contracting and trafficking-related crimes, as well as things like sexual assault or abusive sexual contact, felonious assault. So these are different types of qualifying criminal activity, and in many cases, if the labor-based agency, the certifying agency, detects or investigates a crime in conjunction with investigation in their jurisdiction, so that would include a wage and hour complaint, for example, the individual could request certification because they have been helpful in the detection or the investigation of a qualifying criminal activity. Note that being a victim of wage theft, for example, a wage and hour violation, does not guarantee or qualify somebody for a U visa. It is merely the fact that you filed a request for an investigation by a labor agency that then kind of brings that investigation under the jurisdiction of the labor agency. And then if the person has been a victim of crime that is connected to that particular investigation, is when the agency may start to consider whether or not to certify for a U visa. There is actually a practice manual on this issue. Like I said earlier, I think if you just Google NELP U visa practice manual, there is a pretty lengthy and very detailed explanation as to how you can go about applying for a U visa if you see these types of fact patterns in cases that you have encountered.
Thanks, Eunice. That's very helpful. A great summary of a very complicated area of law very quickly. Thank you. We're running out of time. We have about 5 minutes left, so maybe we'll do about 2 more questions. The next question I think is for any of the panelists. It concerns litigation and some of the things we've talked about today. So someone asks, can you address the risks and recommendations regarding the filing of lawsuits as opposed to proceeding with agency enforcement in wage and hour cases? So can you talk perhaps a little bit about the concerns with filing lawsuits with undocumented clients' names?
Well, this is Tricia. I mean, the first thing to say is that the MOU with ICE and the labor agencies would not apply in a situation where there is a private lawsuit that's filed and you didn't go to the agency and there's not an open investigation with the agency. I can say that just from dealing with the ICE agents both in the original MOU and in the 2016 addendum where we talked about these issues, that they are somewhat skeptical of quote-unquote labor disputes that don't involve another federal agency. We tried to really talk to them about that, but they remain skeptical. So I think is the first consideration. The second consideration is that when the Labor Department has filed lawsuits involving individuals who are also applicants for U visas, we've had a lot of litigation about whether we need to turn over that U visa information. I know that we talked about the Fifth Circuit case, and that is one circuit, but and we've never had to turn it over, but it's been huge. There have been a lot of fights in many cases about that, and so you have to consider that if you're filing a lawsuit and you also have someone who has applied for a U visa through whatever agency, that you probably will have a discovery fight about that.
Thanks, Tricia. That's really helpful. So I'll take, I think, 2 more questions still. I think the next one may be brief. So someone asks generally about I-9 audits or raids. Can workforce enforcement or I-9 audits occur at sensitive locations like schools or universities or places of worship? I don't know if this is something that our panelists have looked into or can speak about today.
So I can talk about that briefly. So both worksite enforcement and, I-9 audits are a form of worksite enforcement, and the sensitive locations memo is meant to stop ICE from doing essentially arrests in the community at the types of locations that are covered by the sensitive locations memo. So that includes schools and places of worship and public protests, and among others. To the extent that those entities are employers, they are subject to the I-9 requirements just as all other employers are subject to the I-9 requirements. I would think that with regards to worksite raids, usually those are, at least recently, they have been criminal investigations and not civil investigations. I think the likelihood of a criminal investigation into one of the sensitive locations as an employer, in its role as an employer, is probably not very common. But that being said, the sensitive locations memo is designed to protect the people who are coming to those places not as employees, but rather because they're receiving services or they're participating in worship services, things like that. So
thank you, Jessie. I'm going to interrupt for a second. I think we have a couple of seconds left. That was really helpful. So I want to thank everyone again for calling in and participating, and I apologize for the tech issues and the problems with the calling in. We will be sending out again an email with a full audio recording of the presentations and a PowerPoint with all the slides that were used. If you have other questions or comments, please feel free to email me. But again, thank you to our panelists, and thank you to everyone who called in.